Good morning, friends. Namaskar, Sat Sri Akal and Adab. This is my 242nd video, and this will again cover the policies of excision. So, the first cantonment which was excised on this policy. This is letter number 18/13 G LNC 521028 LC Director C/L Government of India Ministry of Defence dated 7th February 1955. This letter purely speaks of excision of civil area from cantonments. I am directed to say that the question of the terms on which assets located in the area to be excised from cantonments may be dealt with has been under consideration from the Government of India. It has now been decided that the following broad principle shall be adhered to excise the civil area from cantonments. Cantonment Board's assets and liabilities in area be transferred to the successor local body free from any compensation except for financial adjustment which may be necessary in the local circumstances in each case. Income and expenditure to be divided on the basis of actual income from a source such as octroi, such normally to be divided on the basis of a different method may however be adopted by the local bodies and as warranted in the due course. Third, government rights in the leased sites etc. be transferred to the state government free of cost, subject to the condition that the income derived from such area will be utilized for the residents of that area exclusively. This is very important. Fourth, vacant lands to be retained for future use or eventual disposal by the Government of India. So, even in the civil area, if there is any open land, it is excised, but it remains with the Government of India. MES properties, if any, to be retained and eventually disposed of to the state local body. To report to the extent of the terms on which properties vesting in and belonging to the Cantonment Board should be appointed between the two local bodies. Now, what are these two local bodies? G. The report on needs of the two areas for the construction of new buildings consequent upon the transfer of those existing to the local bodies or the local corporations with a financial aspect. A report on other matters relevant to accession for the financial adjustments of apportionments of assets and liabilities or assignments of easements, amenities is concerned. So, the government has made some 7-8 rules or conditions on which the civil area can be excised. So, 1955 when they do this, in 1957 they transfer the Agra Nimach area, Nimnar area or something named like, spelled like this. Now, in that case, because this report or this conditions does not talk of the land record being transferred. So, in Agra cantonment, the same mistake was done, and till date, after 1957, more than 60 years gone, 65 years, the land records and the approvals of buildings have to be given by the Defence Estate Officer Agra. So, this flaw of this policy made by Mr. Dave, who was the then Deputy Secretary Government of India, remains in existence in Agra cantonment. Luckily, no other cantonment. There were 5 cantonments which were identified, could have been in 1957 excised on these terms and conditions of the policy, but finally they did not get through because only Agra was taken as an example. Even Ambala was to be taken as an example. So, luckily it was only, or unluckily it was only Agra. Friends, we all need to understand what is the accession policy of the government from 1955 to 224. We have to understand what is the government really looking for and what is the core issue behind this accession or delimitation. So, this policy was in place, it was finally sent to everybody. Unfortunately, I remember when I met the defense minister in 2016, they wanted this letter and complete report of this policy, which is with me. I had said that I can only share it if the government is willing to accept some of our terms and conditions, otherwise you can dig into your records. I think the government of India is much bigger than what my records are. I source these records from the DG's office only or from the subordinate staffs of the DGs, the DOs or COs of various cantonments. So, I laid hand on this policy from one DO, I remember in 2000, I think 11 or 12, Dave report, and this report was originally in my father's custody also, because in 1977 when Ambala was excised. So, this Dave report was only considered by the then Raksha Mantri, Mr. Bansi Lal, who had happened to be a very close friend of my father. Please understand once again that we are old grants. We were never converted into new grants. That is why the government is looking for these kind of policies, because Rule 4 or Section 3(4) of the Cantonment Act 1924 very clearly reads delimitation of cantonments or even accession of the vicinity of the military stations which were then created by the British Army, and make them into cantonment after 1864 when the first Cantonment Act was made. So, please understand all this. Thank you. Good day.